the topic is Competition Amendment Act 2023. Basically, Competition Amendment Bill was passed in Lok Sabha on 29th March 23, and after getting cleared from Rajya Sabha on 3rd April, it received President's Assent on 11th of April. 11th of April. This is the first time amendments are being made to the Competition Act post the enforcement of the Act in 2009. Competition Act provides for faster timelines for approval. Amendment Act, I'm saying, faster timelines have been provided for M&A transactions. Certain incentives have been provided for ongoing cartel investigations. If someone discloses other cartels, they are given certain incentives or leniency. And law also has brought in the limitation period of filing complaints for anti-competitive agreements. Earlier, there was no limitation, but now a limitation of 3 years has been prescribed. And many more changes have occurred in the Competition Amendment Act. Now, why competition law or Competition Amendment Act is important to us? Because competition law is a very unique law, I would say. As Mr. Sharma very often puts it, it's an economic legislation or an economic law. It's not a pure, I would say, just a tick in the box compliance law. It is more to do with the business, more to do with how the organizations are conducting their business, how they are writing their agreements, what are the policies, are they anti-competitive? So the essence is, and the whole genesis of the competition law and the Competition Commission of India is to ensure a fair competition, to ensure that the anti-competitive behavior and anti-competitive agreements are not entered. The abuse of dominant position is not done by the large dominant players in any industry, and to ensure free play and a fair play for all the players in the market, all the stakeholders in the market, for overall consumer benefit. So, and also, if some of you who follow competition law, you would have seen huge penalties being levied by Competition Commission of India, running into hundreds and thousands of crores on all the good brands that we use any which way. So it's difficult to imagine how would a Google or a Make My Trip or Oyo or other great reputed companies would run into these kind of issues with Competition Commission. So I think let's hear from the expert now, Mr. M.M. Sharma, to delve into two things. I think I'll initially I'll request him to cover a brief on the Competition Amendment Act. What are the key changes that have been brought under the Act? And then if there's any critical comment that Mr. Sharma would like to offer, being an expert in the law, his own views on whether the Act meets the needs of the shareholders or the needs of the industry or the regulator, or what are his views around it. So over to Mr. Sharma. Sir, if you could share your presentation and take the discussion forward. And as you're sharing the presentation, sir, you can share any audience, if you have any question, please put it in the Q&A box. You see a Q&A box on the right hand side. Please put your questions in the Q&A. We will take Q&A. There are, either in intervening or towards the end. We will see depending on the questions taken. So over to Mr. Sharma.
Thank you, Sumit ji, for this nice introduction, and I'm humbled by the introduction you gave about myself. Thank you very much. So there's no technicality. See, Competition Act, as you very rightly said, is not technical at all. It is more business friendly. It is for the businesses, how the businesses are conducted. And Competition Commission of India is actually a fair market regulator. To see that the markets behave in fair competition and they eat the big, doesn't eat the small. That kind of a situation doesn't happen. The law of jungle doesn't come to the markets. So competition law, as you very rightly said, is an economic law. So this webinar today basically is about the amendments which have been brought into the Act. And this is the scheme of my presentation. I'll first take you through the background of the amendment, why the amendment was actually needed. And then I'll run into specific provisions which are important. Merger control, the enforcement provisions, and there certain new ideas have been introduced. And then the miscellaneous changes for the procedural aspects of the law. And then at the end, as you said, I will cover I'll give my own critical appraisal on the amendment, whether they fulfill the stakeholders' aspirations or not. So competition law, as you said initially, is basically a law which deals with the market. It is the law which every entrepreneur should know. Every businessman should know about the competition, and particularly the medium and small enterprises. The large companies have their legal departments. Everybody has their own, experts with them. But it is the small and micro and medium enterprises which should know this law very well, because they are often the victims of the ignorance of the law. Whether they are either they are changing information through WhatsApp and then they get caught in a cartel, or they are actually being arm twisted by the supplier by not supplying the goods and things like that, and supplying at a very high price, or there is a cartel of suppliers. That's also possible. So ignorance of this law actually means that your profits will go down. You will not be able to grow, and you will not be efficient enough. So basically, competition in the market ensure that you are efficient and you are always on your toes to do the best. That is very well known. So I don't have to repeat it. So why the amendment was needed in the whole place? So this law has been in place for 10 years. 2009, when the law was actually brought into force, 20th May 2009. And since then, the competition regulator has done I would say, fairly good job. Fairly good job, because they have actually handled about 1,000+ cases of antitrust, of cases that they've handled, and about 1,000 mergers. They have actually around 1,000 of mergers they have cleared. So they're actually their work has been quite appreciated all over the world. Competition Commission of India has actually entered into MOU also with the other countries' antitrust authorities, and I have attended a few of them. So they're very proficient and a very efficient regulator. There's no doubt about it. But why the law was actually needed to be amended? So I've just given you the bullet points here. So there was changing business landscape over the period of years. So you see the emergence of newer and disruptive models of business, particularly the digital markets as they emerge. New business models have emerged, and digital markets and e-commerce, for example, they are totally new. The traditional buyer and seller relationships are not there. The platforms are there who have both the buyers and sellers with them on both sides. There are network effects, and they create a different ecosystem which was not known earlier in the normal markets. An ecosystem in which there is a private competition, and then the problem comes when they start behaving, in a preferential manner to players with whom they have their own dealings, with whom they have their own stakes. So kind of competitive neutrality of the platform goes. So I've spoken a lot about it, so I'll not repeat it, but the digital market themselves and the way the e-commerce is conducted is a challenge. It was a challenge actually for the authority, even including the CCI. Then there were certain other requirements like codifying the legal principles. So jurisprudence evolved over a period of 10 years. So new concepts actually came to be noticed by the commission, like supply side substitutability and vertical agreement, like hub and spoke cartels. I'll speak about that later when I touch the subject. Material influence as control on the combination side. So these issues actually emerged because over a period of a year, the CCI, as it passed orders, certain experiences were actually gathered. They were required to be brought into the law, because otherwise, in the combination side, the Competition Commission was mostly, running the show through the regulations. So the regulations have actually not that force of law as an act itself. So they had to be brought into the act. That has been done now. And then the third was the need for bridging gaps in the enforcement of law. There are certain gray areas which were noticed into the law by experts, which, such as, for example, penalty caps. How much penalty can be imposed by the CCI? Whether it should be total turnover or whatever, or etc. Gray areas were there. So gray areas, this is a highly legalistic subject, but I'd suffice to say that there were some procedural, lacuna, like one of the sections of the Competition Act, Section 26, that where the Competition Commission, for example, disagrees with the findings of the DG. Then can it pass an order closing the case? There was no such provision in the existing act. So they used to pass orders which were not available before the appellate tribunal. So there were areas which need to be stated. And then of course, the most important was making the law business friendly. See, we are living in an age where our present government talks of ease of doing business. They never stop of talking about it. So ease of doing business is the mantra of the present government. So naturally, the CCI had to custom itself. So the more and more they make the laws, certain, transparent, and regulatory certainty is brought, particularly in the case of combinations. Confidentiality is handled very carefully. So all those things had to be brought into the law. So that was being done by practice, but now it has been brought to the law. These 4 or 5 areas are the reasons why the act had to be amended, and that's what the amendment has taken place. Now, what actually happened, how this process happened, here's a slide. You can see that the government set up a review committee, the High Power Competition Law Review Committee in October 18, which submitted its report in July 19, and it was placed with the Lok Sabha which now the Competition Amendment Bill was passed, was actually drafted in 2020, but which lapsed because of the COVID, etc. The Parliament never could convene because the COVID came. And then this was revived in 2022 as Amendment Bill of 2022, which I think Sumit has already mentioned that. And it was cleared by the Lok Sabha on 29th of March, after the PSC gave a recommendation in December 2024. So in the current monsoon session, it was sort of winter session was passed, and then finally it was passed by the Rajya Sabha on 3rd April and received the citizen, etc. So basically, now the act has become force. The act has come into the law. Is no question of any debate or anything. So the point is comments by given, but one thing I like to mention is this actually process of amendment actually went for 5 years. It is 2020, almost 4 years, you can say. So the comments were made by the stakeholders, by the various apex chambers of the, such as SOCHM, PSD chair, even CII. So they gave comments to the expert body. The 20 was referred to the Parliamentary Standing Committee. And the Parliament actually did a very wonderful job, because in a period of months, it was referred to them in August 22, and in December they came out with a report, so-called 52nd report. A report actually basically formed. So this bill was actually had PSC recommendations, but I am sorry to say that some of the recommendations were actually not accepted by the government, by the Parliament also. Some of the recommendations of the even the PSC have not been accepted, which will tell critical appraisal. So the specific of consultation has taken place. So this brings transparency into the stakeholders, and that is a good thing. Competition Commission of India at least can be commended. This, this type of function, whether it is the regulations in the amendment bill or the leniency, whatever they come out, they have a fair amount of consultation with the stakeholders.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software, helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000+ laws and 24,000+ compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.